Hello and welcome to this webinar hosted by Security Compass. My name is Eleanor Lee, Product Marketing Manager at Security Compass and the host for today's webinar. Before we get started, I'd like to address a couple of housekeeping items. First, a recording of this webinar will be available after today's event. You will receive an email with a link to the recording. Second, we encourage everyone to raise questions. Please submit your questions into the chat and we'll collect and address them at the end of the presentation. We'll also open up the audio lines at the end of the presentation for questions. If you have attended any of our past webinars, welcome back. And for those of you who may not be aware of us until today, Security Compass started out with a team of very experienced penetration testers in 2004 and has since evolved to become a security software company that offers professional services, training, and SD Elements, a first of its kind expert platform that translates security standards into actionable tasks to improve your security posture. Our mission is to help customers manage cybersecurity risk without slowing down their business. I'm very excited about our webinar topic today, Senate Bill 327, a new standard in information privacy to address the security of connected devices. And I'm very pleased to have here with me Farbod Thumani, Technical Product Manager of Content Research at Security Compass. Farbod has been involved in academic research and industry projects in the areas of smart card Java application development, Java Enterprise e-banking application development, privacy and security in software development, secure design of enterprise applications, advanced signal processing techniques in speech and sound processing, biomedical engineering, and the evaluation of social and privacy aspects of biometric identification. Farbod has published and presented his work on signal processing and security in several IEEE conferences and journals, ISACA journals, crime science conferences and networks, the IAPP conference, and OWASP Global AppSec conferences. He holds degrees in electrical and computer engineering and a PhD with a focus on criminological and security applications of use of biometrics. Farbod, that was a lot, wow. Thank you for being here with me today.
Hi, Eleanor, and thank you for having me here today.
I know you have a rich presentation agenda, so why don't we get started with your presentation? Take it away, Farbod.
Yeah, sure. Thanks for your intro. And hi, and good afternoon, or good morning, or good evening, everyone, based on your location. I'm Farbod, and thanks for tuning in and listening to this webinar. As you know, this webinar is about Senate Bill 327, and I'm very excited about talking about this subject because it is the future of legislative approaches to IoT security. So I'll try to explain the law and give some detail about its evolution and its background and some practical information about how to build security into IoT devices. And I really hope that what I've chosen to talk about today will be relevant to you and will address your interests and will be aligned with your interests and your needs. So let's jump into the heart of the matter. But before we start with the structured approach to this presentation, yeah, I'm far from my microphone. So before we start to follow the structure of the presentation, let's go to the heart of the matter and try to see what is the problem that this bill and this law now has aimed to solve. So in my opinion, the problem, or even based on the documents around the SB 327, the problem is that there are a growing number of IoT devices that are connected to the internet and will be connected to the internet. So Business Insider predicts that by 2025, there'll be 64 billion IoT devices connected to the internet. And that will be up from 9 billion in 2017 and 10 billion last year. And if we tell little bit of calculation, you can see that there are around 100 devices connected to the internet each second. On the other hand, Karna internet census was carried out in 2012 by the Center for Protection of National Infrastructure in the United Kingdom, which is a UK government authority, CNPI. And they found several thousand unprotected devices on the internet. Also, if you look at the first drafts of the SB 327, you'll see that one of the items that they alluded to was that there were 49 million records that the unauthorized access to them have been reported to the Attorney General of California. So this is the real problem that exists in this field, and it will continue to be with us. So that is why the legislators try to address that within their capacity and within their power. So in this landscape, a lot of manufacturers just rely on the security by obscurity. So they think that because no one knows about the strategies that they use or about their algorithm that they use, they're secure. But we know that it's not a best approach, and it's not even an approach, because like if you have worked with some tools like Shodan, which is a search engine of Internet of Things, you know that you can easily find devices on the internet, even if they think that they're hidden. You can easily find them. You can easily find the devices, and even based on the metadata, find out what they're doing, and then you can find the open ports. You can do banner grabbing. You can find all the vulnerabilities on the devices and make use of them. So there is a real problem here, and there will be more laws like this, SB 327, that will try to address the problem based on their capacity, and that is the problem that needs to be addressed. So also there's a lack of documented authentication patterns and best practices in the field, and we'll go through a number of sections in this presentation, and I'll try to share my ideas with you. And I think that all of that will be relevant if you're whether security engineer or project manager of IoT projects, or even executive managers, or even lawyers. And I also have to state that I'm not a lawyer, so despite the fact that everything that I'm saying here is well researched and to the best of my knowledge accurate, you have to seek professional advice for your own cases. So this is the outline of the presentation. I will start with the bill and its evolution, its background. We'll analyze some use cases, and in the third section, I will introduce some IoT frameworks that you can consider in your security development. So let's start from the first section, which is the bill itself, and the legal background and the history of the bill and its evolution. So a little bit about legislative process in the state of California. So we can summarize it as I have shown in this slide. So an idea is generally drafted into a bill in either of the California houses, Senate, or Assembly, and then the bill goes through the first or second or third reading in any of the houses, and after that it will go to the other house. If it's amended in other house, it will go back to the house of origin. For example, if it's initiated in Senate and it's amended Assembly, it goes back to Senate and it's voted again. And if it's approved by the House of Origin, it's sent to the, if it's approved by both houses, it will go to governor, and governor has three options: either sign it, whether sign it or veto it, or allow it to become law without signing it. So most of the bills become effective on the 1st of January of the next year. So as you know, in the United States, the system of the legal system is based on common law or case law. So the prosecution of one case decides the future of the interpretation of the law. So most of the states in the U.S., apart from Louisiana, if I'm right, and also Canada and UK, are based on case law and common law. So additional points about legislative process. After the law is passed, it's assigned a chapter number by the Secretary of State, and it becomes part of California codes. And California codes part 3, division 3 is about, of the civil code is about information privacy. And right now SB 327 is part of the law in that division of civil code. The cases are prosecuted by the California Attorney General, and a law may or may not warrant private right of action. In this case, SB 327 does not warrant a private law of action. It's only Attorney General and some other players that only can prosecute law. And you know that Attorney General is part of the executive branch of the government. So why it's important to analyze SB 327? Because the effect of this law is not limited only to one state, obviously. It's very much like CCPA, because it's very difficult for the manufacturers to control where their products are sold. And it's not a popular decision to create one less privacy-friendly or security-friendly product for one state. So they have to change their line of production, and they have to change their manufacturing processes to build more secure software or hardware. So also, the US is a big market, it's a large market for IoT products. So that for that reason, and for the fact that the manufacturers cannot limit where they sell their products, it will have a global effect. Also, it shows the dominant view and emerging trend and paradigm in the legislative approach and initiatives around security of IoT. So we know that 4 states have similar laws. Oregon has already passed a law that is similar to this, has some small differences from SB 327. Also, we know that UK, and I will explain later that UK has very similar initiatives to pass some mandates or mandatory requirements for IoT security. Okay, so let's take a look at SB 327, which is law right now. So this slide shows the heart of the law and the crux of the law. It's just the law has 2 separate subdivisions. The subdivision A, which is a paragraph on the bullet point on top, is that the manufacturer of a connected device shall equip the device with reasonable security features. And the second one, which is actually has coded the entire IoT security in one subdivision, in one clause. And subdivision B is actually, some people have interpreted it as an escape clause, but it is not an escape clause. So subdivision B says that if a connected device is equipped with a means of authentication outside of local area networks, it should have a unique password, or it should contain a feature that requires the user to generate new means of authentication, right? So it's not, subdivision B is not escape clause, or it doesn't limit subdivision A. So subdivision A is very broad, and it talks about the entire IoT security, and subdivision B is just one specific case that applies in some circumstances. Also, the law defines connected devices and says that it means any device or physical object. There should always be a physical object that is capable of connecting to the internet directly or indirectly, and should receive an IP address or Bluetooth address, which for Bluetooth devices, all of the Bluetooth devices have will have a Bluetooth address, and every device that connects to the internet will receive an IP address. So it's not very limiting. So this is a flowchart or a decision tree or a diagram that I've put together after talking to several people and after hearing about some misconceptions that exist here. So this is a flowchart that helps you understand whether you need to be compliant with SB 327 and how. So you think that the first question that you have to ask yourself was that, are you manufacturing a device or a physical object, right? If you're just creating software and it's not used in any devices, then you don't have to worry about SB 327. Then the second question is that, is it capable of connecting to the internet? If yes, either directly or indirectly? If yes, is it assigned an IP address or a Bluetooth address? Again, if yes, then you have to inevitably equip the device with reasonable security features. And then this is not enough, but it's actually needed. It's not something that you can escape. But if your device also has authentication, then you should either have a unique password, or you should generate a first-time authenticator for the first use, or you can do something else. This is very important to understand. Those two are not, the options that you have are not limited to those two. You can do something else that provides the same security measure and the same level of security. So the if in the text of the law is not if and only if. You're not compliant if you do one of those things. You can do the third thing that is as secure and as strong as those two options. So key facts about SB 327. So it's already signed by the Governor of California. It will come into effect in more than 2 months in January 2020. Its title ties it to privacy, but a lot of the mandates and the requirements actually, if you saw that in subdivision A, is about security of connected devices. And also, as I mentioned, and for the reasons that I mentioned, the effect of law is not limited to one state. So enforcement of SB 327, as I mentioned before, like the exclusive authorities are Attorney General, City Attorney in California, County Council, or District Attorney in California. So I've marked, so this is the timeline of SB 327 from 2017 up to the time that it was passed. And I've marked 3 important dates on the timeline of the law. So I've tried to read anything that I could get my hand on about the bill and different versions of the drafts. And in my opinion, these 3 points are important. So if you look at the draft in May 2017, the draft talks about existing law, it talks about importance of IoT, and it gives some examples of hacked toys. And it also asks for privacy and security protection for devices, and it talks about reasonable security features, and it also asks for devices to have some signals to some features to get consent from the users or show notice of recording. So these 2, notice and consent, were removed from the draft in 2018. So when after the 3rd reading, it was amended. The draft of the bill was amended in Senate, and they removed notice and consent based on some of the feedback that they got from the industry that this is not possible. It's not, for a lot of IoT devices, not possible to give notice or to ask for consent. Then in 2018, later in 2018, the draft went to Assembly, and they also changed it. So they reconciled the draft with AB 1906, which was a separate bill that Assembly had around the same subject. And it was at that time that they added Subdivision B. So Subdivision B appeared in the law because they wanted to reconcile the Senate bill with the Assembly bill. So it wasn't even in the draft of the bill. So it's very important to note that, because some people think that the emphasis is on Subdivision B, but the emphasis is actually on Subdivision A. So what are the aims and motivators of the bill? It's very broad: protection of privacy and security. And then if you look at the earlier drafts, they have given examples of hacked connected devices. They mentioned a toy, a doll that was called My Friend Kayla, and it was connected to the internet, and it had Bluetooth capability, and it collected personal data. And the objection was that intruders or hackers could talk and speak obscenity to the children that played with the doll. They also mentioned baby monitor system, another toy that was cloud-based. They mentioned reports that some of the smart and connected TVs collect data from users without them being aware of it. And these were the concerns of the initiators of the bill, or the senators that proposed the bill. The other points that were mentioned in the bill was that there were 657 breaches reported to Attorney General between 2012 and 2015. And with all of that information, you can see that what the initiators of the bill were worried about was the whole security of IoT. So it's this bill and this law right now depends on and leans on a number of other regulation and laws that exist in California. So California has a constitution that mentions privacy, and like many other states, or even in the Fourth Amendment in the Constitution of U.S., privacy is not clearly in a broad sense. It's not clearly mentioned, but California mentions privacy. Also, there is another law in the Civil Code of California that talks about protection of customer records, and there were some discussions around SB 327. Some people said that we already have this law, so why do we need a separate law for IoT? There are also data breach notification laws within the state of California, and there are also, I think, 35 or more than 35 other states that have similar laws. California also has disposal of consumer information laws and drone privacy law, which was a little bit controversial when it was passed. So, so the point of that slide was that in order to understand SB 327, you have to understand the context of it and all the similar laws that underpin it. So SB 327 exemptions. So if you are creating software, or if you're an unaffiliated third-party software developer, then you don't have to worry about SB 327. It only applies to you if you're creating, if you're manufacturing hardware or physical objects. Also, electronic store and marketplaces are exempted from SB 327, so they don't have any responsibility and accountability for the hardware and objects that, or connected objects that they sell. There are also two new areas that the law has tried not to interfere with, in my opinion. It doesn't mean that we don't have laws in that area. The first area is that federal regulation. So the law SB 327, the senators tried not to interfere with federal laws and also with the healthcare laws. So HIPAA and CMIA, they didn't want to interfere with those laws, but HIPAA has similar mandates and requirements, which is absolutely equivalent to SB 327. So it doesn't mean that they're exempt. It's just they wanted to keep these two areas separate. Okay, so the summary of SB 327 legal analysis, as I said, it was designed to protect privacy and security of users. Context matters. So if you're manufacturing something that has anything to do with children or anything to do with families, you have to be more careful. It's an extension of existing laws to IoT domain. California had some similar laws, and it needs to be understood in light of existing law, and it's not absolutely a password law. So I've read some articles on the internet. I think there are still blog posts that say that call this password law and give some not 100% accurate advice about how to comply with SB 327. It's not a password law if you read the context and earlier versions of that. So the second section of this presentation is about analyzing some use cases. How can you make sure that you are compliant with SB 327, and what's the approach that you have to take? So I borrowed this list from Etsy documents. It's not from SB 327 text, but this list gives a pretty good idea about what different categories and device types are there. So if you are a manufacturer of connected children toys or baby monitors or safety relevant products or smart cameras or connected home automation and alarm systems, connected appliances, all these are definitely in the scope. The SB 327 is definitely relevant to the manufacturers of these devices. But more importantly, even Bluetooth headphones and mobile phones and laptops, and I think for mobile phones and laptop, it's huge because basically SB 327 says that all the mobile phones and laptops need to be secure, need to have appropriate and sufficient security measures and features. Okay, so I think when it comes to the analyzing the applicability of the law, it's important to focus on subdivision B because it's most problematic for a lot of people, and let's see how subdivision B applies in one or two of the common use cases. So this is a common pattern that a device connects to the internet. So I elaborated more on the technical aspects in my OWASP AppSec Global talk in DC 1 or 2 months ago, but I'll be more succinct here. And I'll just explain one case here, which is a smart thermostat. So usually there are some devices that are connected to a local area network within the perimeters of a house, and then there will be access to those kind of those devices from outside, either through application server that enables the services on the devices, or through clients that can connect to the wireless router. And the wireless router usually does NAT and PAT, which is a layer of security, but it's not enough. So usually the outsider can get connected to those devices. But what is the process for bringing what is smart thermostat into the for connecting a smart thermostat to the internet? So it generally works like this. So you connect the thermostat to wireless LAN. It may happen through an ad hoc wireless network, or using Bluetooth, or entering your password on the panel. And then the thermostat receives a newly generated code. And that's the important part. And it's generated by a server, is passed to the thermostat, and user enters the code on their mobile app in order to recognize the thermostat, and then the user can control, from that moment on, the user can control the thermostat on their mobile app. So from that moment, there will be a session that is established between the device and the server. And this session management is a well-known subject in the field of security, or even in the field of web application development and web application management. So there's many ways that you can maintain a session, and all of them are, or at least a lot of them are acceptable in this context. So it's similar to when you open a tab on your browser, and the authentication and session maintenance may include using SSL, TLS, like session IDs, or a combination of above. But in a lot of these cases that we analyze, you can argue that a new means of authentication before the first time is used and is generated. So in most of these cases, unless you really want to do a bad design, the requirements of subdivision B are satisfied. So I suggest performing the analysis for everything that you want to do in the same way that I've done here. So examine the case through the phases, through the lenses of two different aspects: applicability of the law and compliance. So here in this case, like for example, if you want to analyze the smart thermostat, you look at applicability. So because it connects directly or indirectly to the internet, so the law applies to it. And does subdivision B about authentication apply to this? Yes, it does, because it has a means of authentication. In terms of compliance, because a new means of authentication is granted, then it's compliant with B, but still A applies, like subdivision A applies. So you have to equip the device with reasonable security feature. And generally, the law amounts to equipping the device with reasonable security features in most cases, which makes it really broad. And I think that brings us to the third section of the presentation, and that is the IoT frameworks. And why does it? Because we saw that the law amounts to or boils down to reasonable security features, right? And we also saw that those reasonable security features are under-specified or not sufficiently detailed in the law. So we'll have to get information about those reasonable security features from some other sources. And in the third section, I will give you some pointers to the other sources that are available on IoT security. And by following the guidelines that I'm trying to lay out here and outline here, you can argue that you have met the requirements of SB 327, in particular, subdivision A of SB 327. So we'll look at OWASP IoT Top 10, attack surface project, which is part of the OWASP Top 10, OWASP IoT Top 10. I'll also mention ASPS 4 Appendix C, which a lot of people don't know about it. A lot of people don't know about ASPS 4, 3 or 4, and also they don't know that it has an Appendix C that talks about IoT devices. I will also talk about the UK government code of practice for consumer IoT, and also mention the ENISA recommendations for IoT security for IoT development. Okay, so let's start from the code of practice. So code of practice, it's created by DCMS, which is part of the UK government. And DCMS is the Department of Digital, Culture, Media and Sport, and it's part of the UK government. And it consists of a number of documents, and one of them is code of practice. So there is a secure by design collection, and it consists of a number of documents. One of them is code of practice for consumer IoT security. They have also mapped this code of practice to a lot of different IoT regulations and other IoT frameworks, including OWASP Top 10. And the part of the collection is also ETSI Cybersecurity for Consumer Internet of Things document, which has exactly the same 13 guidelines or recommendations as the secure by design, as the code of practice, and but it's more detailed. So code of practice is in lay term, and it's just layman term. It's in layman term, and it's just in simple terms for everyone to understand. But ETSI documents is more detailed. Also within that collection, you'll find another document for password, related to password security, which is called Simplifying Your Approach. So these are the 13 recommendation or guidelines within the Consumer IoT Security Code of Practice. So if you look at the first three ones that are shown in red, the first one is no default password. And you see that this is exactly the same thing that subdivision B of SB 327 suggests. And the second one, recommendation or guidelines implement a vulnerability disclosure policy. And the third one is keep software updated. So UK government, so again, DCMS on behalf of UK government also ran a public consultations from May to June 2019 and asked various players in the IoT field about these three mandatory requirements that you see on this page. So those three mandatory requirements are all IoT device passwords shall be unique. The second one is that there should be a vulnerability disclosure policy. And the third one is that the device should receive security updates. So they led this consultation, and then the UK government is analyzing the responses and will publish the analysis. But the important thing is that if you look at these three proposed requirements, they're exactly based on the code of practice, and the first one is exactly what SB 327 in particular asked for. So one can argue that these three are in the mind of people that are these three are based on the current paradigm that we have in this field. The legislative paradigm, you can say, are the most important items that you need to take care of. The other two documents that I want to briefly mention is that OWASP Top 10. So OWASP IoT Top 10 generally outlines the security issues that exist in the field of IoT, and it also has a sub-project which is IoT attack surface, and both of these projects approach the security of IoT from a vulnerability-driven approach. So if you look at the documentation of OWASP IoT attack surface, you see that it gives a list of attack surfaces that the manufacturers need to look at and understand and reduce, and try to reduce those attack surfaces and mitigate the risk associated with them. But in order for you to do this, you have to have a security engineering team that looks at this list and identify the relevance of each of these items to your own project and your own product, and if necessary, finds and takes threat mitigation actions. I also want to mention ASVS 4 Appendix C, which talks about security verification items, for security verification requirements for IoT devices. So it is an invaluable source of information. I actually saw that someone called it a treasure trove of security on LinkedIn yesterday, which I completely agree with. So the other source of very useful information is an ENISA recommendation, European Union Agency for Cybersecurity recommendation about IoT. So they have published baseline security recommendations, and also for security recommendations for smart cities and smart cards. There are, I think, over 80 controls in ENISA documents, and some of the recommendations are difficult to understand. So this is a source of pre-populated controls, but some of the controls, if you look at them, for example, in the example that I've shown in this slide, it's not very easy to understand it, or it's not very practical and practical to do this. So you still need a team of security engineers to understand it and apply it in your own case. Again, if you look at this slide, the top item that I've shown is about default passwords. So if you even look at ENISA, you see that this completely is aligned with the requirements of SB 327. And if you see on the right side, they've also mapped to the other documents that exist. So again, I'm suggesting, I'm probably summarizing this here. So I would like to also talk about our own experience. So we look at all of these documents, and we looked at different taxonomies that exist in this field, and also different standards, frameworks, IoT frameworks, IoT protocols. And we also defined security goals, weaknesses, and variants. And then under each weakness that we defined also several problems and security controls. And right now, SD Elements knowledge base consists of over 550 problems and 1,350 security controls. So this gives an idea of the size of work that we have. Obviously, not all of these controls are applicable in all the projects. So we have just defined a matching condition system to filter those controls and filter them down based on the parameters of each project. But it will be a huge endeavor for each company that wants to do this, and we've already done this. So, so this brings us to the last section of this presentation and webinar, which is just a summary of the facts that I mentioned. So let's go through all of these facts. So IoT security risks are real. As we saw, there are many devices that have poor security design. The goal of the law was to regulate both the privacy and security of connected devices. Its original scope even included consent and notice, which they removed in the later versions of the law of the bill. It's not a password law, as I mentioned several times. And also many other states have similar laws, including Oregon, which has already passed the law. And it also shows the prevailing view and the dominant view and paradigm that we have in this field that is manifested in SB 327 and UK guidelines. So I tried to give you some action items and good pointers and takeaways in this presentation. So my recommendation is that I start from UK Code of Practice 13 guidelines, especially focus on authentication, vulnerability disclosure program, updates. Make sure you have these three you have taken care of these three main mandates. Also, just note that subdivision B does not apply in many cases. And also use OS attack surface, use OS IoT top 10 and ISVS, and you need analyze the architecture and component that you have based on those documents and cross-examine your list with an ESA document. And there are more IoT frameworks that are mapped to code of practice if you go to their website. You definitely need a security engineering team to develop security controls, and you can also use available tools for IoT security management that have pre-populated tasks. Definitely one of them is SD Elements that Security Compass offers. So that brings me to the end of this presentation, Eleanor.
Thank you so much, Farbod. Thank you for a deep dive on Senate Bill 327. Lots of great insight there and a very interesting discussion on how organizations can start complying with it. So at this point, we would like to open it up to questions. We've got a question from the audience. We're just over a month away before the bill takes effect. What are you seeing as the main challenges for IoT device manufacturers in complying with this bill?
I think the main challenges, I mentioned in the presentation that I see a lot of misconceptions in the way that people interpret the bill. I think that is one of the challenges. The big challenge is the ambiguity in the bill. A lot of people don't know what it means to have security features, appropriate security features, but in the bill there is some ambiguity, but on the other side, people interpret this law as being just a password law, which is a misconception. I think all the challenges that exist in IoT security are here. Like, so the law is broad and it asks for something that is ambiguous, but at the same time, it asks for security and privacy measures. Yeah, I think not enough information that this manufacturers have is the biggest challenge.
Okay, thank you for that question. We have another one. How does SB 327 compare with CCPA, which is the California Consumer Privacy Act?
So CCPA, I can see some differences. So for one thing, CCPA was, as far as I remember, as an assembly bill. So this is a Senate bill. But apart from that, CCPA so SB 327. Let's think about which entities SB 327 applies to and which CCPA is relevant to. So in general, the scope of SB 327 in that sense is narrower. So only device manufacturer need to comply with SB 327. But on the other hand, a lot of companies need to comply with CCPA, even if they're just active in the IT field. Also, on the other hand, I think CCPA requires, so in order for in order for CCPA to apply to you, you have to meet one of the three requirements. One of them is you have to be over a certain size, you have to have a certain revenue, and you have to earn that revenue from handling personal data. In that sense, then SB 327 is different because all of the manufacturer of IoT devices are in the scope. The other difference is that CCPA is more detailed. So it's, as opposed to SB 327, it's sufficiently detailed and it has some sections or mandates or clauses that explain, similar to GDPR, explain what needs to be done. There are some ambiguities there as well, but SB 327 is very high level. It just asks for protection of security and privacy protection in IoT devices.
Okay, I think I don't see any more questions from the audience. Thank you so much, Bob, for sharing your expertise on this subject. Again, to everybody, we will provide a link to the recording of this webinar via email. Do join us in our webinar next month for an expert discussion on continuously monitoring security architecture. For more details, please visit the resources page on our website at securitycompass.com to sign up. Thank you again for attending this webinar and have a great day.